People versus Nektalov.
Good afternoon, Your Honors, and may it please the Court. Rachel Pecker of the Legal Aid Society on behalf of Mr. Nektalov. I'd like to reserve 2 minutes for rebuttal, please.
Yes.
I won't raise all the issues as I briefed them, but I would like to make sure to get to 2 issues, the entire basis of the stop, as well as the 3030 motion here today. So taking it from the beginning, the entire basis for the stop here was the alleged excessive tint of the car windows in which Mr. Nektalov was merely a passenger. At the suppression hearing, the testimony of the arresting officer was that he stopped the car because, quote, it had excessively tinted windows, period. That is a completely conclusory assertion. He didn't provide one other word, not one description, articulable fact, or basis for his conclusion.
With respect to the word excessive,
Yes.
is that not describing what the officer saw in his belief and basis for
No.
stopping the car?
No, Your Honor, and that's for 2 reasons. One, Your Honor, the word excessive is a subjective word, and the word excessive means different things in different states. The legal tint in New York, what is excessive in New York, is very different than what's excessive in other states.
But you can't even determine what is invalid or illegal amount of tint until you actually stop a car and use a tenometer, correct? Or something like that.
To know the exact number, that's correct, but I would not agree with, I think, the presumption of your question. I'm going to go back and answer the second part of your first question and then get to the second part, which is that excessive is not enough for the same reason that saying a knife is a gravity knife isn't enough. Because
So what would be enough?
Great question. So what would be enough? So based on this court's jurisprudence, in People v. Smalls and in People v. Theum, the court indicated that a police officer saying only that an officer had experience and training on its own would not necessarily be enough. But even if this court said experience and training were enough, that the officer had experience and training and identified excessively tinted
Is that in the
windows New York-
conjunctive, experience and training? So I've taken a class on excessive tinting, and I have a notion of what that is, and I've stopped 12 cars, and 6 were extensive and 6 excessive, and 6 weren't, so now I know the difference. You need all that?
No, I think it's an or, Your Honor, experience or training. And the court has indicated that wouldn't be enough, but even here, we don't have even that. So going back to Judge Halligan's question, let's say, what would you need then? An officer could testify about his experience or his training and some description or some basis for how the officer reached to the conclusion that he did. And this goes back to Judge Troutman's question. What would that look like? To wit, the windows were so dark I could barely see through them. They were so tinted I couldn't see the driver. They were pitch black and I couldn't see through at all. That's what the numerous cases that I cited.
What if they had a tintometer at the scene after? Would that be sufficient?
So, Your Honor,
And it showed that it was excessive. So in other words, corroborating his excessive testimony.
that also is better than what we have here, and I think it would be up to the suppression court. So often, the suppression, although we judge the police officer's belief at the time that he made it, suppression hearings are inherently retrospective, and the prosecution...
What about the fact, did he have to be correct by using the tenometer that it was in violation of the vehicle and traffic law? Or did that merely have to be the valid, objective reason that the stop was in fact made?
No, Your Honor, he didn't have to be correct. This court has held clearly that if an officer has a reasonable belief, even if it's a mistake of law, that doesn't undermine the probable cause in the first place. The problem here is that a court, the neutral fact finder, had no way to know how the officer formed his belief. And just as saying that a gravity knife is a knife is a
So if
gravity
he-
knife tracks... Sorry,
No, go ahead,
Your Honor.
finish.
Just as saying a knife is a gravity knife tracks the definition of gravity knife, and saying a window is excessively tinted, which excessive isn't used in the law, but a window is tinted in excess, you could cite the law. That wouldn't be enough because the officer, the court would still not know how this officer formed his belief.
So your argument is that the people, it was their burden to establish that there was a valid reason for the stop. They didn't meet the burden by simply offering the term excessive.
Correct, Your Honor. It's a conclusory statement.
But if one believed that they had met the burden at that point, it would have been on the defense to show that it wasn't a legally valid reason that they were in fact stopped. The burden would have shifted at some point.
Sure, but here we're just, the burden is on the prosecution. I mean, for 44 years, since People v. Boughton, this court has said that it is
No,
the prosecution
that is clear,
incumbent.
the burden is on them,
Yeah.
but your premise is they never met their burden initially.
They
So
didn't
the
meet it.
defense
Correct.
could simply sit on their hands. Because here, there was no cross-examination, correct?
Correct, Your Honor. This was the entire suppression hearing was 10 pages. That's unheard of. It is the prosecution's burden to elicit testimony, and they simply did not do that here. And their duty to elicit this testimony and the court's ability to be the final arbiter so that it is the court and not the police deciding whether a police intrusion is justified is all the more important in the excessively tinted windows
But just to be
context.
clear about your position, if I
Sure.
can.
Yes.
So it sounds to me from what you've told us that if the officer had testified both, that she had experience, she'd stopped X number of cars that were excessively tinted, or training, in other words, she took a class on what that looks like, and secondly, she said something, however brief, describing what she saw in the moment. I could only see the outline of the driver's face, couldn't see anything. That would be sufficient.
Absolutely, Your Honor. If that, I mean, we don't know the other facts before the suppression court, so let's say it was really dark out and there was no street lighting. A suppression court might decide, take that as he will, or depending on the race of the driver. But yes, under what we would expect, that would be enough. It's not an onerous requirement. They just have to give some basis.
What
And
about
it's-
when an officer says, I was following a car and I saw it swerving and I pulled it over? Isn't swerving a conclusory statement, and we've said that that's okay?
No, Your Honor, because there are certain acts that objectively on their face are a VTL violation. If an officer sees someone run through a red light, if they see them fail to signal, if they see them go over a yellow line, swerving, the fact in itself is the violation. But if you're saying a subjective, a conclusory statement only that the windows were excessively tinted, we don't know how this officer concluded these windows were excessively tinted under the law. And in New York City, stops for excessively tinted windows now far exceed stop and frisks. And that is relevant to this court's weighing in here to say that the prosecution has always had a burden to state how the officer has reached the conclusion that he has, because tinted windows are now a leading basis for police-citizen interaction. And just as stop and frisks were, tinted windows are a way that police are
So going
fishing for more
forward-
serious crime, yes.
So you acknowledge that they can be stopped for tinted windows, but it would be your rule that excessively tinted is not enough for the people to meet their burden at the suppression hearing, that they have to establish the basis of the conclusion, because unlike a stop sign or the double yellow line, which is what it is, there's some subjectivity involved in it?
Yeah, and I would say that's not my rule, Your Honor. It's going off this court's precedents. Under Dumas, saying a substance is marijuana is not enough. A conclusory statement in Dryden or Brannon at a suppression hearing that a knife is a gravity knife is not enough. It would never be enough for an officer to say, I arrested him for a DWI because he was impaired, period. The court has to have a basis to know how this officer concluded that there was probable cause for the stop. So there was many ways for the burden to be met here. The prosecution has had that burden for all along.
My
and
question to you is,
Yes.
if I say to you, I'm the police officer, the windows were excessively tinted, and then at the hearing, it is elicited that I could not see the driver, or I had difficulty seeing the driver, or I used, in addition, the words pitch black, et cetera. So that is what I'm asking you about, because you clearly acknowledge that it is a violation of the vehicle and traffic law to have a certain percentage. It varies from state to state. No one expects officers to know what it is for other, because there are instances where it could be legal in one state, but not in another, correct?
Yes, and the examples that you just repeated that's pretty strong proof that the statute here has been violated, because the whole point of this statute in New York State is that we want police officers to be able to see into cars. So when they say they're having trouble seeing into cars, that's pretty strong proof that there is a violation of the statute.
They should just say it. They should
They
say
should
what
say
the...
how they concluded, yes, that it was too dark, 70%. And just, sorry, going back to I never answered your question about the tintometer. often at suppression hearings, the prosecution enters evidence that was acquired after the fact of arrest to provide corroboration, context, or to provide information to the court on why this officer's belief was reasonable at the time, even though it's after the fact. And that's what a tintometer, that's what
Can I
pictures
ask
do.
you a question about how you articulate this rule? Assume we want to adopt your rule or our rule, wherever it comes from. We know that we can have this, to use your word, conclusory statement that the windows were excessively tinted, but there's a plus that you say needs to be there. What is the nature of that additional statement, regardless of what it is? Can you describe, does it have to be based on verifiable criteria or measurable something, or really can it be anything that adds to confidence in the statement about it being excessive?
It's under this court's holdings, it's the prosecution has to put forth sufficient evidentiary facts for a court to determine how the police officer reached the conclusion that he did.
So it doesn't necessarily have to be a tintometer reading.
No, that's just one way, and the cases on page 29 of my brief outline all the ways that one could get to the burden here, and they simply just didn't elicit any testimony whatsoever.
If I can take it from another direction,
Sure.
say that the officer had not said excessively tinted windows, but instead said a violation of whatever provision it was, because I couldn't see through the window. You would say that's okay, correct?
I think that's pretty, it would be up to the suppression court, but I think that's pretty strong proof of what the, of a violation of what the statute was
And you're
intended.
saying what the problem was, and that, of course,
And
is...
that's clearly, I
it's the
couldn't see through
tinted
them, is
windows.
how he reached the conclusion that he had a violation on his hands.
Because you can have tinted windows.
You can have tinted windows, Your Honor, yes, you just can't have 70%,
Correct.
more than 30% tinted.
Correct,
So it
correct.
seems like the rule has relatively broad implications, which may not be bad ones, but for example, if an officer says, I stopped the person because the person was driving recklessly, that wouldn't be enough under your rule, right?
It's never been enough
Yeah.
under this court's
Yeah.
rules, that's
You would need to
correct.
say recklessly because, and then give some reasons that you observed.
Absolutely, and that's what this court has always held.
And how exactly do you articulate the distinction between driving recklessly and swerving? Is it because swerving is a sort of physical, path that we all objectively appreciate in the same way, and recklessness might be different? What's the
Sorry, I
distinction?
don't know if, this is my, I don't know that swerving is a VTL violation, but it might be, I apologize if it is. So I guess I was, when the judge said swerving, I was
I don't
thinking
know
about
either,
going
actually.
over a yellow line, but absolutely, if swerving were
Let's say going over a
subjective-
yellow line.
So yellow line is an objective violation on the face, but if it were swerving or reckless that have definitions and meanings, then the officer would have to describe them. If I could just turn to the 3030 motion and the appealability, of 3030 subsection 6. First, I want to say, Your Honors, that this is not about retroactivity, and the prosecution's use of that word is a misnomer. This is about the prospective application of a statute that conferred jurisdiction to appellate courts as of the effective date. And the prosecution says that 3036 should apply prospectively, and we say absolutely, because the plain language of 3030 subsection 6 is that 3030 denials shall be reviewable on appeal as of the effective date. And the legislature could have said 3030s shall be reviewable only for convictions entered into after the effective date. But they didn't say that.
And his guilty plea does not foreclose?
His guilty plea does not foreclose this, no, Your Honor. In Landgraf, the Supreme Court undertook an analysis on how you decide when a statute is genuinely retroactive and when it's presumptively prospective. And the court said that a statute is retroactive only when it impacts a substantial right and adds new, unforeseeable penalties, impositions, obligations. And in contrast to that, a statute is presumptively prospective only when it confers or ousts jurisdiction and changes which tribunals have the power to hear a case, whether or not the appellate court had the jurisdiction to hear the case when the case commenced. And the court, in holding that, making that distinction, pointed out, as is relevant here, that a statute is not retroactive merely because it applies to cases arising from conduct that antedated the statute. And it is not
What if it revives the right that you've forfeited or waived?
reliance interests. I actually think that is not actually applicable here because the Supreme Court said that a statute is similarly not retroactive merely because it upsets expectations based on prior law. And so, if you look at what this court did in Galindo with 1E, the court said subsection 1E impacts substantive rights. It adds timeframes to traffic infractions that the court held the prosecution could not have known it would have and could not foresee, and therefore it would not apply retroactively. However, subsection 6 is not retroactive. It confers jurisdiction to the appellate courts, and the prosecution had the same obligations all along. Under the old law and on appeal, if this court looks at the merits of the 3030 motion, the prosecution's actions are viewed under the same law, under 3031B all along at the trial level and on appeal. He had 30 days to prosecute the case. And I think, if I may, take a moment to point out Slack v. McDaniel, which was raised by the amicus in their brief, because in Slack v. McDaniel, the Supreme Court applied Landgraf to reach essentially the exact same question that this court is grappling with here regarding 1E versus subsection 6. That is, when there are two parts of a statute and one is directed backwards at trial court proceedings and the other is directed at appellate jurisdiction and going forward. So in Slack, the court was considering AEDPA, and it affirmed that the first portion of the new AEDPA statute, 2254, was directed at trial court proceedings, and therefore it would not apply retroactively. It would apply prospectively, and on appeal, any petitions that were filed before AEDPA went into effect would be governed under the pre-AEDPA law, and that is exactly what this court held in Galindo vis-a-vis 1E. And the court then went to the second part of the AEDPA statute, and the second part, 2253, was about appellate jurisdiction. And the court said, this provision too applies prospectively to any appeal taken after the effective date because it was only conferring jurisdiction. And the court held, which is the same here, that Congress made no indication that it intended the right to appeal of AEDPA to apply only to cases initiated in the trial court after the effective date. And therefore, the plain words of the statute said the appellate provision applies as of the effective date, and so it must be so. The same is true here. The plain words say that the appellate provision goes into effect on the effective date. And they did not indicate that it would go into effect only for convictions secured after the effective date. And that is also what the appellate divisions held in Sullivan and Rosen regarding the predecessor to CPL 71070, the appellate provisions, the amendments that allowed appellate courts to review motions to suppress, denials of motions to suppress, notwithstanding a guilty plea. The appellate divisions there said there is nothing in the plain words of those statutes that indicate that the legislature wanted this appellate review power to apply to future convictions after the effective date only. And the appellate divisions reached that without dispute, and the prosecution never sought
Counselor, your
leave to
red
this
light's been
court.
on for a while, and you have a
Okay,
little
thank you
rebuttal
very
now. Yep,
much.
thank you.
May it please the court, Joseph DiPietro on behalf of District Attorney Melinda Katz.
With respect to this case, the defense indicates that unlike a stop sign, a red light, or the double yellow line, whether or not a window is excessively tinted requires some subjectivity. Therefore, in order for the people to have met their initial burden, simply saying excessively tinted was insufficient. What do you say to that?
Well, Your Honor, I would first begin with what the people have to establish at the suppression hearing. They have to establish that the officer, quote, reasonably believed that the windows were over-tinted. That's the exact language.
But if you simply, the argument is, if you simply use the word excessively, what is your basis for that? And how could the reviewing court make a determination that it was, in fact, a reasonable belief?
Well, at any probable cause hearing, it's always going to be a fact-specific inquiry. And it's those facts are always going to arise out of the nature of the crime.
What facts were elicited here in this hearing to make a determination about the reasonableness of the illegality of the tint?
So there's one relevant fact. It's the detective's testimony, and he said that he observed a car traveling with excessively tinted windows.
So
Counsel,
that's it, excessive,
I'm sorry.
correct?
I'm sorry, Your Honor?
That's it. The word excessive is
That's
the
correct.
culmination of the facts in this case.
That's correct.
Counsel, I'm sorry. So I was trying to, along the lines of this back and forth on, right turn without signaling or failure to come to a complete stop where that's an obvious violation. You say, I saw the person come to the stop sign, they didn't come to a complete stop. I was trying to think of an analogy to this, and I thought about before radar guns, right? And you pulled people over for speeding, what did you need to show, right? And I actually found a case that's from 2022, believe it or not, when they had a radar gun, but the officer didn't have one. And he testifies the person was going at an excessive speed. In fact, he says, I think they were going 82 miles an hour in a 65 mile per hour zone. And the fourth department says the people failed to establish the officer's training and qualifications to support the officer's visual estimate. Isn't this the same case? I mean, excessive is a visual estimate. And what supports the visual estimate here?
Well, I think in the case of window tints, they're rather unique among all of the vehicle and traffic law violations that an officer might encounter while he's looking at cars on the road. It's a rather irreducible analysis, unlike the case of speeding, where in order to establish speeding, a car is traveling in motion. So the question is not, is it stationary or is it moving? The question is, how fast is it moving?
Right.
That's quite
But
distinct.
with respect to the window, it would not have required much for the officer to simply state objectively what he witnessed in order to form the basis of that conclusion that the tinting was in fact excessive.
Yes, Your Honor. There's no dispute that, the officer could have been more verbose in his description.
But wasn't that the prosecutor's responsibility to bring out?
Going past one word is not quite about verbosity, but thank you for that.
Yes, Your Honor. The
Very
question, of
entertaining.
course, before this court is whether it was legally sufficient, not whether it should be a case study in the elicitation of testimony with respect to window tints. And here, the officer used the word excessive, which is important. As Your Honors have previously discussed with my opponent, a certain degree of window tint is lawful. And by...
Let me ask this. Does the law permit some of the windows not to be tinted?
Yes, Your Honor.
Yes, okay, so it's only particular windows that cannot be quote-unquote excessively tinted?
That's correct.
30% line? Okay. Did the officer ever indicate which windows were excessively tinted?
No, he did not.
Well, why isn't that, forget the excessively tinted then, why isn't that the problem?
I think, Your Honor, in this case, the suppression court credited the officer's testimony and made inferences in the people's favor, which were reasonable, that by using the word excessive, the officer was both, one, implicitly referring to the statute by saying excessive means exceeding the legal threshold, and then two, by saying windows, the court could have reasonably inferred that he was referring to the front windows because those are the
Why?
only, Your Honor, because those are the only windows that are covered by the statute. It would
So
have,
you're saying the court should assume, speculate, as opposed to having the officer articulate what he actually saw or didn't see?
I think, Your Honor, it would be a reasonable inference for the suppression court to make.
That is a lot of inferences.
It's an inference, however, that's informed by the statute. The statute is omnipresent.
But again, there was discussion earlier about, even if you want to call it a hearing, it was minimal. There wasn't much effort put forth, or do you disagree with that?
No, I agree with Your Honor that it certainly more could have been said.
Let me go back to Judge Singus's question. Suppose this is legally sufficient. How does an appellate court review that?
Well, the appellate court first makes, deference to the suppression court's credibility determinations. Here, the officer said that he saw an excessively tinted
So there would be
window.
no way to review that. That would be unreviewable.
Yes, Your Honor. In Shabazz, the 2003 case from this court, the court held that the legality of a motor vehicle stop is a mixed question of law and fact, and such questions ordinarily are subject to deference.
But
to the
how would the appellate division even review that with simply the single word?
I think the appellate division would look at whether the suppression court One, credited the officer's testimony, which it did here, and then two, drew inferences, reasonable inferences from that
The word
testimony.
excessive alone. What I'm grappling with is this. So I have some very rough sense of what excessive tinting might be, but having had no experience stopping a car or training in what crosses the line laid out in the statute, I couldn't tell you whether something was excessively tinted as set forth in the statute or not. And it seems to me like the reviewing court should be able to know that the officer making the stop is better equipped to do that than I would be. But with that one word, we have no insight into that, nor does the appellate division, I think.
It is a difficult position for the appellate division, even on a perfect suppression record, to make that review, because if an officer uses a tintometer to determine the exact level of tint, that's really irrelevant to the analysis of whether the court
But
could...
it's agreed that the officer didn't have to be correct in the assessment that it was excessive tint. The question is, how can one judge whether it was a reasonable conclusion? And you're saying that there are all of these inferences that the court's simply supposed to make. The officer doesn't indicate what he observed. He just uses the one word. These circumstances, I would agree with you, credibility is a part of it. If the officer even took time to explain how long he drove, what the lighting was like, what he could or could not see, it's just a few more words. But that's not here.
Your Honor, I would note that the officer, before going into his observations about the window tint, he described his experience. He said he was a police officer with the NYPD for 7 years. He said that he had 2 years of experience in the narcotics bureau.
Anything about tint stops?
Yes.
No, Your Honor.
See, you're saying, and I get what, he's a police officer, he's a narcotics officer. One can infer that he's had training, he's had experiences. Maybe he did, maybe he didn't. He could have been assigned elsewhere. How long was he in narcotics? And how did he pull people over based upon tinting? And how did he make those conclusions? We don't have that in the record, do we?
I think, Your Honor, while it's important that he testified about his experience as a police officer, that's not even the kind of primary inquiry. I think most people who have any interaction with cars on the road can tell with zero training or experience that either a window is entirely opaque.
And I would agree with you there, but I would say excessively tinted. I was unable to discern if it was a male or female driver. I'm giving a basis of what some would say is subjective. One person may say it's not excessive, it's just stylistic. But if there's no light going through, all of the things that would help to see if it's reasonable. The thing that I'm grappling with, and you see, I was just as determined in my questioning with respect to the defense, but the objectivity, how do you review it if I just have a word when it's not like a red light, it's one color or another color, it's a double yellow line, or it's not a line?
Your Honor, I would like to mention, in response to your question, I would like to draw the court's attention to Booten, People versus Booten, the 1980 case, which my opponent relies on in her brief, which discusses what constitutes conclusory testimony. There, a police officer said that he was familiar with the case, that he was familiar with the content of a radio transmission, and that probable cause existed. That's the kind of testimony that this court has held to be conclusory, because it all comes back to the central inquiry of the standard that people are held to at the suppression hearing.
Well, it does seem, certainly from some of the questions to both sides here, that what the jurisprudence and what the questions have led to is there's not much more that needed to be said. It's not a overly burdensome standard. Would you agree to that?
It wouldn't be especially burdensome.
Okay, so then, contrast that with the potential for pretextual stops and the great danger that is involved in such a stop. Doesn't it make sense to follow the case law as it exists and to expect the officers to very easily comply with those requirements and just put a few words more?
It would constitute just a few more words. However, this court has...
To avoid the potential for the pretextual stops.
Yes, Your Honor, but this court has expounded on that same notion in the context of controlled substances in Dumas, where the court said that it's not necessary that once an officer establishes training and experience in the identification of controlled substances, then it's not necessary to supply, in this court's words, a few extra words that a
Yeah,
substance...
but again, you missed the beginning of the premise there that you started with, which is, what's your training? What's your experience? You've got to say something.
Well,
You've got to say something. The officer could have said something. This is not such a demanding standard that we make it impossible for officers to do their job.
I think here the officer did establish his training and experience. He said that he was a police officer for 7 years, and which is important not to be overlooked, is that...
Can I just take you another way?
Yes, Your Honor.
If we agree with you and find that this was sufficient to establish excessive tinting, what do you think would be insufficient to establish insufficient testing? In other words, if we agree with you, are we just rubber stamping these stops?
I think if the officer had said that he observed tinted windows, which there is case law in the appellate division regarding, that is certainly inadequate, because tinted windows are not illegal.
Well, why
So-
can't we make the same inference you were talking about before, which is the officer knows the statute, and if he's stopping a car for tinted windows, it implicitly means excessively tinted?
If an officer says only that he observed tinted windows, that doesn't even begin to allege any criminal activity. Tinted windows don't violate the vehicle and traffic law. Only excessively tinted
No,
windows.
I think the
I
point the
understand.
chief was making is, a short time ago, you told us that based on the bare words excessive tinting, a number of permissible inferences were made by the suppression court here, that it was the right windows, that it was the right amount of tint, and et cetera. Why couldn't we do the same thing if an officer just says tinting?
I think it's because any inference that is to be drawn can only be drawn from testimony that actually alleges facts that support any kind of allegation of criminal activity. That's ultimately the question of whether the officer had probable cause. So if an officer simply states that he saw tinted windows, he has no probable cause that any VTL violation has occurred. Whereas if he says there's excessively tinted windows, then that implicitly
Yeah, but
refers
see,
to...
that's the problem, excessively tinted windows, because you can have some tint, doesn't really set out that there is a violation of the VTL.
And, Your Honor, I think implicitly by stating that the windows were excessively tinted, it's in reference to the statute. and
What if he
that-
said heavily tinted?
I think that's functionally analogous to excessively.
What if he said they're too tinted? T-O-O.
I think that's getting closer to simply tinted, but it still probably would
What
suffice.
if he said they were problematically tinted?
I think no. I think that's entirely... that-
Problematic, I know. Okay.
Your Honors, if you have no further questions with regard to the tint, I'd like to address the 30/30 retroactivity question. There's no question here that constructing the statute in the way that my opponent desires would implicate retroactivity concerns. The recent case of this court, Regina Metro from 2020, makes very clear that statutes, absent the unambiguous statement of the legislature that it should be construed retroactively, should not be when they would upset reliance interests.
So what was missing in the statute, in your opinion? What should the legislature have put in to make it clear that indeed they intended it to have retroactive application, the way you've defined it?
I think two things. One would be first removing something from the statute, which is the fact that it delayed the implementation of the statute by 8 months, which there's ample case law from this court that that's indication that the legislature did not intend it to apply retroactively. And then the second point is very simple. The legislature could have said that this embraces all cases currently pending on appeal. There's nothing that prevented the legislature from saying that unambiguous statement of retroactivity, which is what this court has repeatedly found to be necessary for retroactive construction. Here, the reliance interests are well established and invade every single guilty plea. The people have a strong interest in the prospective certainty and the retrospective finality of plea agreements. When the people enter into a plea agreement, they do so for the precise purpose of, one, ending...
But there's always the possibility that on appeal, an appellate court might decide that the plea is involuntary, correct?
Of course, Your Honor. There are exceptions that this court and the legislature have found, removing for public policy reasons the extinguishment of appellate rights. However, the statute here was unambiguously not one of those. In People versus Taylor, it was well established by this court that by
Well, I'm saying the fact that there's a plea doesn't mean that the plea is going to survive an appellate challenge. That's all I'm saying.
Yes, Your Honor. A plea itself could be challenged on appeal, but the rights extinguished by that plea under case law or decisional law or the statutory law, those, generally speaking, do not survive a guilty plea. And Taylor unambiguously established that here. The defendant had absolutely no expectation that he would have the right to appeal the speedy trial, the statutory speedy trial claim here when he entered into the guilty plea. And for that reason, the court should not construe 3030 to extinguish the people's expectations and bestow on the defendant a right that he did not expect to have survive the guilty plea. So if Your Honors have no further questions, then the people rely on their brief.
Thank you.
Thank you.
I'd like to just say a few brief points for the reasons that the Chief Judge and Justice Halliday mentioned, and as held by Justice Weston in her dissent. Even if the police officer was completely credible, everything he said was credible at this suppression hearing, the court, whether the appellate court or the suppression court itself, simply had no way to independently evaluate how the police officer reached the conclusion here. And he didn't talk about his experience in training because he never even mentioned whether he's had a car stop before. His experience in training was in narcotics, not in rules of the road and car stops. And we have never presumed that probable cause exists simply because a police officer says so, and the same is true here. As for the retroactivity conversation, retroactivity, again, is a misnomer, and for that reason, Regina's analysis doesn't apply here. The plain words of the statute say the appellate provision went into effect on the effective date, and the interests, Landgraf said, even when there are reliance interests in the prospectivity analysis, they're diminished. And here, there's no strong interest in trying to insulate a time-barred prosecution and a meritorious 3030 denial from review. It's simply the expectation, diminished expectation reliance are simply not relevant. The legislature wanted 3030 denials to be heard by the appellate court and to be reviewed, and they wanted that to happen as of the effective date. And for the rest of the issues, we rely on our briefs.
Thank you.
Thank you.